The estate tax. First of all, there is an estate tax right now. So what the IRS does is they take your gross estate. They add up everything you have. What's in your gross estate? What's included in that? And there's some obvious stuff. Come on, give me some obvious ones.
Home.
Your home's in there. Okay, what else is in there? Your
bank accounts, investment accounts, 401ks.
Are your 401ks in there? Yeah, that's true. What about life insurance? Is life insurance in there?
Yeah.
Life insurance is in there. Most people, if you ask them, the question is life insurance taxable? Is life insurance taxable? What's the answer to that?
Depends.
Well, it depends who owns it, but often people think it's a trick question because most of the time for income tax purposes it's not taxable. But for estate tax purposes it's included in the estate. But as you guys know, it does depend who owns it. Given that most people haven't done their estate planning, most people own their own life insurance. So that's included in your estate when you own your own policy. You have an estate, it's $10 million, you take $3.5 million off the top, and then there's an estate tax on the rest. It's currently scheduled in 2009 to be $3.5 million. Last year it was $2 million, and this was a number that was $600,000 for many years and has been increased. So there's a $3.5 million number that comes off the top. Now, next year there is scheduled to be a repeal. And as Phil pointed out, most likely they will change the law, although it's not a guarantee they will change the law. When I do my planning, I hope for the best, which is that they change it, they, extend the full repeal, but I plan for the worst. So what does planning for the worst mean? At least in my opinion right now, planning includes taking into account a $1 million number. If they don't change the law, that tax rate goes up. The tax rate's been reduced. It goes up as high as 55% when it goes back to prior law. So that is a very large estate tax that we need to take into account. We have a couple case studies. What we're going to talk about is probably the biggest bang for the buck when it comes to estate planning. And any married couple who's got any reasonable level of net worth should have this sort of tax planning built into their documents. And if they don't, then this is something you should be talking to them about. Case study number one is based on our worst case scenario of we're dealing with a $1 million number. What does it take to be in that situation and have an estate tax problem? We have Fred and Wilma here, no relation to anyone famous. And in this case, I put down a couple assets that they have. They have a house, it's probably undervalued at $400,000. It's not hard to have a $400,000 house today. That's a condo. They've got a brokerage account, a few other things. Fred's got an $800,000 term policy. Wilma's got a $400,000 term policy. Now, Fred dies in 2011. Wilma dies a few years later, 2015. So what are the estate taxes on that? Fred dies first, so we're going to add up all of his assets. And when we add it all up, he had $400,000. He had an $800,000 life insurance policy that he owned. $1.2 million. Now he's over the $1 million amount. Forgot to mention one thing about the estate tax. There's an unlimited marital deduction. You can leave $1 billion to your spouse and you don't have to pay any estate tax as long as they're a U.S. citizen. $1.2 million in total assets, full marital deduction. There's no tax on Fred's death. We like that. That's a nice, efficient tax strategy, or result anyways. But now what happens when Wilma dies? Okay. Well, when Wilma dies, she's got $1.2 million she just inherited. She had $400,000 of her own assets, and there's a $400,000 life insurance policy included in her estate. So she's got $2 million in total assets. She dies, leaving the children, or leaving her daughter everything. Now, what are the taxes? If she has $2 million and she dies, what are the taxes going to be? You can give $1 million tax-free to their daughter. The second $1 million gets hit with a tax, and it's $435 in that case. That's a pretty big tax on someone that has $2 million in total. Now, Fred had $1 million he could have left to anyone without incurring a tax. And Wilma had $1 million. They should have been able to leave $2 million to their daughter, right? Without incurring $435,000 in taxes. But what happened? Why do we have this huge tax? We have this huge tax because we didn't use Fred's credit. Fred, we wasted it. Fred gave everything under the marital deduction. So here is the single biggest bang for your buck. You'll save your clients $435,000 at least. If they've got millions of dollars, and we're talking, a $3.5 million number, you're saving your clients millions of dollars here. Scenario number 2, we're going to use what I call a credit shelter trust. You might also hear it called a bypass trust or an AB trust. They're all the same things. They're just different names for the same things. So how does that work? Let's go through the same scenario that we had before. Fred's estate. Fred's got $400,000 in assets, $800,000 in a life insurance policy. He's got $1.2 million total. He leaves those assets, instead of leaving it all to Wilma outright, we're going to put $1 million in a trust for Wilma's benefit, in a credit shelter trust for her benefit. Everything else we give outright to Wilma. Now, what are the taxes on Fred's death? He left $1 million to a trust, but he can leave $1 million to whoever he wants. So there's no tax on that. And then the $200,000 left over went under the marital deduction. As we said, the taxes on his death are still 0, which is a good result. Then Wilma dies. Well, Wilma got $200,000 from Fred. She has $1 million in a trust, but she got $200,000 outright. She had her own $400,000, and then there's the insurance of $400,000. So if you add all that up, she's got $1 million in her estate. When she dies, she leaves that $1 million to her daughter, and she can leave $1 million to whoever she wants, and there's no tax there either. So instead of paying $435,000 in taxes, they're paying 0. Now what about the trust? This credit shelter trust, that went to their daughter too. Is there a tax on that when it goes? The answer is no. It passed tax-free. We dealt with it back at Fred's estate. If you're over $1 million, if this is the law, this makes sense to do. So we definitely want to build the ability to fund one of these into a trust. Now I will say I have changed the way I draft my documents. When I used to draft them when the number was $600,000, you automatically funded. We did this thing called mandatory funding because it was a no-brainer. You put $600,000 in, and that was as good as you could do. I don't necessarily mandatorily fund anymore. Normally the decision, well, let me ask the question. What's the decision going to be based on as to whether or not you want to fund a credit shelter trust? The first question I'm going to ask is the level of assets. Because if the number is $3.5 million and they made it permanent, and my clients are never going to be near $3.5 million, they're going to be at $2 million tops, I don't need to fund this, at least for tax purposes. Now the other things that you would consider are maybe creditor protection, because there is a creditor protection associated with it, and some people might want to fund it just for that reason alone. But, or because their spouse is not financially savvy and they would like the concept of having their assets in a trust. Or maybe there's children from a prior marriage sort of thing. So we're definitely putting assets in trust. For tax purposes, we're looking at how much you have in the way of assets and what is the status of the law. So those are the two questions. And because those two things are in flux, I don't know whether or not I want to fund this for sure. So instead of saying I absolutely fund, I do something called disclaimer funding. What that says is the documents actually say I leave everything to my spouse outright. But if my spouse, upon my death, feels it is in their interest to fund the trust, what they can do is they can say, I don't want this asset, and I don't want that asset. They can pick and choose. It's called disclaiming. When you say you don't want an asset, it's called disclaiming. So I disclaim this, I'll take that one, I'll disclaim that one. Everything you disclaim goes into the credit shelter trust. That gives them the flexibility of making that decision. And right now, I think, given where things are, that flexibility is very valuable. There is a detriment to that. You have to be guided through the process because you can blow a disclaimer. You have 9 months to do it, but if you ever take control of those assets, well, now you can't later disclaim it. And people do that inadvertently all the time. Insurance company calls you and says, hey, we've got this insurance policy. You say, no, I don't want it. I haven't talked to my attorney. Okay, well, we'll just hold it here in an account in your name. Well, guess what? That's now your asset. They moved it to an account in your name. They can't do anything. You can't let them do anything. You can't let them sign anything. They need to see a professional. And they're making decisions when it's not necessarily the easiest time to make decisions. So that is the downside. But when I weigh those and I discuss those with the clients, overwhelmingly, we take the position that it is more beneficial to have the flexibility. and they just know to come in and see, you know, a professional, either me. I actually put in my documents, come see myself or another estate planning attorney to help you make the decision.